I'm the living, breathing man on the land and soil. The beneficiaries make a special appearance sui juris propria persona under fraud, menace, and duress before fiduciary basher.
Defendants just simply have not created a genuine issue of material fact.
No offense, lawyers lie all the time.
Those are the plain facts.
And you being the trustee in this case doesn't matter?
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one.
From the start, it's obvious this man isn't over his head. He clings to a crumpled piece of paper like it's a study guide, stumbling through phrases he barely understands. At one point, he even insists on clarifying that he's a living, breathing man, as though that needed proving. Meanwhile, he accuses the prosecution of dishonesty while reciting fabricated legal theories about the UCC and imaginary Supreme Court rulings. It's the courtroom equivalent of trying to pay your bills with monopoly money and getting angry when no one accepts it. The further he goes, the more it feels like he's either convinced himself this is real or too deep to back out now. What do you think? Is this delusion, desperation, or both? Let's get back into it.
Mr. Cowgill, I did, just so you're aware, I did read through your response and attachments. So if you have, I'd like to hear what argument you have in response to counsel.
Without prejudice, I, Jeffrey-Lawrence Cowgill, with Teresa-Ann Cowgill, the beneficiaries make a special appearance sui juris propria persona under fraud, menace, and duress before fiduciary basher. This is a cesticate trust action, which you are now a real party in interest to. I'm the living, breathing man on the land and soil. The dead entity, all caps, Jeffrey-Lawrence Cowgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all-caps entity, and Gary Basher serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authenticated record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you, that there's a UCC-1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitutions are admissible under 56B, as it states, the defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiff says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional acceptance. The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer. We conditionally accepted the offer of the plaintiff, but the plaintiff ignored us, knowing that the conditional acceptance stated acquiescence would void the original contract. The postal tracking combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange? Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted evident affidavits that they are not qualified to submit, how can their words be trusted?
This defendant launches into a 10-minute monologue, clearly believing he's about to drop a groundbreaking legal argument. In reality, it's a jumble of sovereign citizen buzzwords that the judge dismisses in seconds. And let's not forget what this entire case is really about. A man fighting tooth and nail to keep an RV he stopped paying for. Beneath all the theatrics, the strategy boils down to one empty phrase, "I don't consent," as if that were an actual defense. Watching it play out, you can't help but wonder if he truly thinks this will work or if he's simply putting on a performance. Either way, it's exhausting, and the court isn't buying it.
They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, The plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies and procedures, but they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent? No offense, lawyers lie all the time. Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract, so let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original. And that alone poses a major question. Where is the original? Is a signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion what is and is not a bill of exchange. And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain? Esquire Bertolino states that the instructions on the 1099A state tangible property is not included, yet the exact wording is no reporting is required, meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2, C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud or some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud. And if you use it without prejudice, like I have, a 1099A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC. And with that, I'm done.
Here's the thing. You can't scribble fake laws on a paper and expect them to erase your debts. If it worked, everyone would be debt-free and living in mansions. That's the fantasy sovereign citizens keep chasing. Personal rules that override reality. What makes this even more concerning is how easily this mindset spreads. Imagine a child being taught by their parents that contracts and laws only count if you agree to them. It's not just a bad legal strategy. It's a complete denial of accountability. And that seems to be the theme here. Refusing to take responsibility, shifting blame, and wasting the court's time. This case is an exception. It's part of a pattern we're seeing more and more.
Any brief response?
Thank you, Your Honor. The retail installment contract expressly provides that the borrower the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract. And they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally, or my colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations, no demonstration of fraud by the credit union or by anyone. There is no, defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is, those are the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, I mean, there's a lot of interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and it seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time, there was an issue arose where you decided to do something different, and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment. I guess my answer to that is those probably would not be something you could walk into Safeway and buy a banana with, because it wouldn't be considered regular money for purposes of buying things in a retail situation.
I didn't expect this hearing to turn into a duo act, but here we are, two sovereign citizens doubling down together. They sound like a mismatched comedy pair, tossing out legal jargon and waving around homemade contracts as though that carries real weight. But the reality is simple. You can't type up your own agreements on a laptop and expect the court to treat them like law. If that logic held, we'd all write letters to the IRS claiming we don't owe taxes. The bigger issue here is respect. It's one thing to struggle financially, but it's another to demand that rules don't apply to you. Every person in that courtroom, the judge, the lawyers, the clerks, had to sit through a 30-minute rant about imaginary loopholes that don't exist. And the sad part? These cases aren't rare anymore. Should courts start imposing harsher penalties for wasting everyone's time? Or would that just fuel another round of bogus lawsuits? Let me know what you think in the comments.
They may work in a UCC type thing or something. That this is simply a consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has a security interest, which is indicated in the title as the legal owner. And I've not heard. I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments. You make the payments, they get the trailer back. So, I am going to grant the motion for summary judgment. In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back and then they sell the trailer to somebody else. They apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. Does that make sense? So it's in your best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union, because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm trying to point out it's.
And so my copy of the contract not having a signature from the dealership doesn't matter.
It really doesn't.
And you being the trustee in this case doesn't matter?
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one
I
as the
did-
beneficiary, because I'm not to do that.
Okay, I'm not able to accept that as a Superior Court judge.
So what about them just putting out our social security numbers without our say so? Like, they could have completely ruined our credit. Someone could have those numbers and be doing damage to us right now.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. And I'm not saying you do or you don't, because I don't know enough about those, even based on all the information that you filed. You filed, and I read through all the stuff you filed because it's what I do when I do my job. So,
So can we have those forms of payment back?
I
Can
would.
you order them to return those to us?
Well, I think it's appropriate if there's some value in those should be returned to
There's a lot of value in them if they still have them. And if they don't have them, then
What happens if they don't return?
Today we got one of the wildest sovereign citizen cases you'll see. This defendant stopped paying for his RV, then marched into court claiming the dealership committed fraud. In reality, it looks more like someone trying to turn a bad financial decision into a free ride. Instead of accepting responsibility, he's doubling down with baseless arguments, hoping the court will magically erase his contract. What makes this so compelling is the judge's response. She doesn't waste any time cutting through the noise and making it crystal clear that this kind of stunt won't work. The big question is, does this man really believe the story he's telling, or is he just gambling on the system to let him slide? Either way, it does not end well for him. Let's dive in.